Nobody will stay here that long. I'm never gonna get monetized. Good day. How you doing? Abraham Lincoln. Hi, Dr. Random. Hi, Elias Mendez. Why you calling me a good boy for? No, just cereal. Don't forget to like and subscribe. Oh, 418. Two more, that'd be 420 like the weed. UWU. What does that mean? What you? Oh, one more. One more. Then it's 420. You like my shirt? It says slut. You see? Look, slut. No, I didn't get a boob job. It's blitz. I don't even have boobs. Kevin Jackson, let's time you out. That was weird. Like, sis, don't make comments like that. This is not. Somebody did unsubscribe. Oh well, it happens. Hi, Sean B. Look at my shirt. I know I saw it earlier, but look what it says. It says SLU, the weed type sign, and then T, slut. I'm 10. I'm gonna remove that comment, but no age talk. If we talk about age again, I'm gonna block you. $4.20. Woo! My favorite number, 420. 419 again. People will be playing with these numbers. It's annoying, but 418. It's some idiot probably that's got 2 accounts. I got nothing better to do. Control. Like, what's the point of trolling somebody? Like, you go to YouTube, you don't gotta. People got no lives. They gotta go to YouTube. People like that's the only thing people go to YouTube is like to troll other people. Like, come on, guys. Yeah, I could do better than that. I don't have to be trolling me. You don't have to be coming here and trolling me, guys. Like, I know some of y'all, you know, or like, yeah, because they know you're right. But I'm not the only one that watches my subscriber count. Every YouTuber does that, and it's annoying, because it's I find it rude and annoying. But people don't care. Because I bet you if it was done to them, they'd be upset, but I don't even like, and it's not, and it's childish. Like, only children do that shit. Like if you're an adult, like, you shouldn't be doing like that. I understand if you're a child, like, you want to play mind games and stuff like that, but like, adults shouldn't be doing that. Like, don't come, like, if you're gonna be a YouTuber or you're gonna go somebody's stream, act adult, like, act mature. Don't come here, or don't go to anybody's YouTube channel. Like, don't go to anybody's YouTube channel. They'll be rude. Like, it's either they got no life or they're miserable. And it's a miserable love company. And it's usually the young people. It's not like people our age are not like, and it could be people our age too, but it's usually the young people that act like that. Let's see what's going on YouTube these days. The what's going on the because but how's your day, Sean B? Let me look up the Karen Reed. Karen. Let's see. Yo, shit was 2 hours long. So I guess
Election kicks off in defendant Karen Reed's retrial for the death of her boyfriend, Boston police officer John O'Keefe. Over 100 jurors have been summoned to report to court today, and this process could take weeks. Earlier this month, Judge Beverly Cannoni denied Reed's request to delay the start of her trial.
I'm not going to grant the motion. All right. We have jurors coming in that were summoned months ago. What I will do is we'll start impaneling on April 1st. It will likely take a while. If we get a jury before April 25th, I'll rehear you on your motion. We won't swear the jury because obviously that's when jeopardy attaches. And we'll take it from there. But we will start April 1st with impanelment.
So Reed's retrial is going to look a bit different than the first time around. So there's going to be an extended
jeopardy attaches because right now the federal courts are deciding whether or not to dismiss the two charges she was. And then if she used that, she could to ask the United States Supreme Court to dismiss the case, which I think the United States Supreme Court should. Would they? They probably would. So, which can take months. So, because when it comes to this trial might not even take a while. Because yeah, I don't understand. Just go her on trial for manslaughter, and that's it. Like, if she's acquitted, then she's acquitted. But don't retry her, and then if it's another hung jury, you gotta retry her again.
buffer zone put in place. You know that shot we always take in front of those courthouse stairs where lots of action is? Well, that's all gone now. Also, there's a new attorney on the defense team added recently. Well, two new attorneys technically, but one of them added very recently who served as a juror. She was not a deliberating juror. She was relieved of her duties. She was an alternate, but she has been added. And she doesn't practice criminal law either, by the way, if you were wondering. All right, so who's going to be an ideal juror for Karen Reed and for the Commonwealth of Massachusetts? We have a tremendous power panel to talk about this. Let's welcome these brilliant ladies in. With me, former prosecutor Melba Pearson, retired FBI special agent Jennifer Coffindaffer, and podcaster and host of the Roberta Glass True Crime Report, Roberta Glass. Good morning to you all. Melba, I want to start with you, please. As an attorney, looking at both of these sides, who would be the ideal juror for the Commonwealth and then for the Reed team?
So good morning, ladies. And I think this is going to be a very tough one from the standpoint that you have to be basically living under a rock to have not heard about this case. So to find a juror that has not heard about this case at all is going to be virtually impossible. But what both sides are going to be trying to do is to find out whether or not the potential juror has any preformed ideas or preconceived notions as towards guilt or innocence. So anyone who's sitting there that already is like, Karen Reed is not guilty, end of, or Karen Reed is absolutely guilty, end of the story, both of those jurors would be bad people, in other words, for this particular case. And I think also both sides may be interested to know about potential jurors' feelings about law enforcement, because I think that's going to play a critical role as well. If you don't believe anything that law enforcement says because you've had negative experiences, that'll definitely influence the way that you'd be looking at the facts of this case. And also the opposite is true. If you're somebody that always believes law enforcement and has a strong feeling or attachment towards law enforcement, you might be viewing the evidence in a skewed manner as well. So those are some of the things I think both parties are going to be looking for.
Yeah, great points, Melba. Jennifer Coffindaffer, the stealth juror concern that the Commonwealth surely has. Your thoughts on that, and also whether this additional attorney could be helpful in possibly picking the ideal jurors for the Reed team.
Well, good morning, Julie and panel. First of all,
so you really win a trial during jury selection. So during jury selection, that's when you really win a trial. in my opinion. Like if you know how to pick a jury, you have a better chance of winning a trial. But if you don't know how to pick a jury, you screwed.
I think that it's going to be very difficult to avoid a stealth juror getting on. They will be practiced. We know the questions. They have been out publicly, so they can go ahead and practice what they will or will not say. What I think is really important is that the counsel really watch what and how these individuals are responding to these questions. That's going to be key to try to figure out if they're lying or not. So I'm hopeful that there will be good individuals there to scope that out. As far as the defense's brand new attorney that was on the prior jury, I don't know if she'll be really that helpful. First of all, she's not even a criminal attorney, as you well pointed out. And second of all, I think she's there more to give guidance regarding some of the points that should be made that hit home with the jurors in the previous trial.
Great points, Jen. Thank you for that. Roberta, last but certainly not least on this point about the jury selection, I wanted to ask you about something. I enjoyed listening to you so much about how you really dive in and have talked a lot about illusions that have been presented in this case in particular to try to convince the public. And when you think about it, who's really in that jury pool? I'm wondering if the people who are at home, not at that courthouse, not engaging in spewing hate online, I'm wondering if those people are going to come out and present themselves as the fair-minded, honest, good citizens that you would want on a jury who aren't looking to take the case one way or another. I'm wondering if we're just not hearing from those people, if that's going to be our pool. Curious, who do you think is going to get picked for the pool?
Well, I mean, we think that everybody, when we talk about true crime, follows true crime, but not everybody follows true crime or even court TV. So we're looking for someone not who so much doesn't know about Karen Read, but doesn't have a set opinion and can look at the evidence in a fair-minded, rational way that doesn't think, what if something really improbable happened, and hasn't been touched or influenced by Karen Read and her enablers' innocence fraud campaign.
Exactly, Roberta. You want somebody who's not going to have been influenced or looking to tank the case in any way. And I'm just wondering if what we see, we see people outside, and sometimes the most obnoxious and loudest people, are not the reflection of the community. And Roberta, I'm curious, you've talked to a lot of people, done a lot of interviews and work on this case. Curious if you think what we see out there is truly a reflection of the community in Dedham.
I think some of it is. I think she does have some support, but I think it's probably exaggerated. I think it's a very well-crafted, well-thought-out, well-funded, certainly, propaganda campaign. I think most people, I think most people are curious about the case, and I don't think the majority are the Free Karen readers. No, not in that community. Although I do think she does have her supporters. Yeah.
Roberta, thank you for that. Excellent points. Here's what I want to do. I want to play for you all a clip that has really circulated and gone viral. Dave Portnoy, the head of Barstool Sports and the owner of Miss Peaches, who's beloved online, has taken notice of the case and started talking about it. Let's take a look.
Get ready with the Karen Read stuff. You just said she's guilty, so just get ready for that crowd. That's the craziest crowd of all.
Are you afraid of Turtle Boy?
Me? No, I'm friends with Turtle Boy and I are buddies.
I said I would not vote her guilty, but if you gun the head, I think she did it.
I think the weirdest thing of all, she's doing this right now.
It's crazy.
That's what I don't get.
She does seem fairly unsympathetic that the guy's dead.
Okay, so that was just a portion of the conversation. Melba, you were just hitting on how you have to be living on another planet to have not heard about this case, and especially after the investigation discovery doc, more and more people are digging in and weighing in on this. Would you mind speaking to the idea that I think it's often overlooked. It's okay for someone to have heard about the case or thought about it or, maybe formed an opinion. What isn't proper in having someone on a jury?
Well, what's not proper is for you to come in already with your mindset as to what the verdict is. Because remember, when you come in to a case, what you hear, what we see reported on Court TV and other outlets is not the entirety of the case. You're not necessarily hearing every single piece of evidence that the juries heard in the first trial. We heard bits and pieces and all of that. So when you're actually the juror on the case, you have to have a completely open mind and listen and evaluate the evidence and compare that to the law and then make a verdict based on that, not based off of what a podcaster said or what you heard a commentator say or whatever the case may be. Just listen to the evidence that's in the courtroom. So again, it's okay to have heard of the case. It's like any high profile case, whether it's Diddy, whether it's, Henry, Epstein or Weinstein or any of these high profile cases, R. Kelly, you would have heard of them, but you just cannot have already formed an opinion as to their innocence or guilt.
Exactly, Melba. You can have thought about it, but once you take on that oath and that service, you have to say, okay, I'm willing to let go of anything I previously thought or might have thought I believed and just totally judge the facts on the evidence. So to your point, Dave Portnoy could be on this jury if he could say, look, I can follow the law. I can, I might have had some opinions watching that documentary, but I'm going to be a good citizen and listen to the evidence and judge the case therefrom. All right, we're not done talking about this. Our power panel staying with us. We're going to hit our first break. When we come back, we'll talk about the big ruling that came down yesterday from the court on that third-party culprit defense that Karen Reed's team has been trying so hard to put forth.
Based off of our investigation at this point, right, we have determined that there's probable cause to go ahead and charge you for what happened.
Let's come out here, Christopher. It's okay.
No. Okay, so listen.
An Arizona father rejecting a plea deal in his daughter's death. We're talking about why. That's straight ahead. Potentially allow them to point the finger at Brian Higgins or Brian Albert if and only if they can support their claims. She wrote, quote, counsel cannot mention potential third-party culprits in opening statement, but will be given the opportunity to develop the theory throughout relevant evidence at trial. So she's taking that incremental approach that she did last time, essentially saying, if you can put forth the evidence to substantiate your claim, then in the end, I'll give you the jury instruction on it. But remember, the first time, they couldn't do that. So they didn't get the jury instruction. Let's take a look back at the first trial. Alan Jackson arguing about the defense theory, accusing Colin Albert as being a suspect.
The Massachusetts State Police should have, if they were doing their due diligence, they should have investigated this young man. They should have investigated every single person that was in that house, in or around the home of where John O'Keefe was found, the Albert home, and they didn't. They did nothing to investigate whether or not there was someone in the house who tended to fight, who wanted to get in physical altercations, who had a propensity to get in physical altercations, who was a fighter by nature, who threatened to fight, who threatened violence. That's what this young man has indicated he does constantly. I'm surprised he didn't show up in this hearing with busted knuckles.
So does this go to your third-party culprit defense?
It goes to both. It certainly goes to both, but yes, it also goes to our third-party culprit defense as well. This is a focus of, I believe, this should be a focus of the juror's attention in terms of, is there a third party who could have done this? The evidence points to that may have done this. Absolutely, this evidence, what we now have, points directly in that. It's focused in that direction. So yes, both it should have been investigated, and Colin Albert is somebody that the jurors should focus their opinion on or their attention on to determine whether or not he could have or was involved in the death of John O'Keefe.
I'll tell you what sickens me. That young man wasn't even there. And the harassment and the torture and the bullying that he experienced because of these wild, unsubstantiated claims were disgusting. Absolutely disgusting what happened to that young man. Let's talk about this some more. Let me bring in Jennifer Coffindaffer, Roberta Glass, and want to welcome in attorney David Bruno. Jen, let me start with you, please. You know a lot about this. This claim about Colin Albert the first time around didn't come without consequences, did it?
No, it didn't. I mean, this young man wasn't able to go to college because of the harassment he was suffering. He had an opportunity to play football. He wasn't able to do that either. So concerned about the harassment, about being followed, about being really tortured for being a murderer at 17 years old. Yet he wasn't even at the location when Karen and John O'Keefe arrived in the SUV. Also, John O'Keefe never entered, and again, he wasn't even there. And Julie, they showed photos of Colin Albert's knuckles on February 26th, not showing the photo of his knuckles on February 9th, and which were clean. It was just absolutely what they did.
Right. And we know John O'Keefe was killed by someone in January. And if they had shown the photo where his knuckles were fine on the 9th, Jen, you're right, that wouldn't have led to all the confusion with the jury that Judge Cannone is preventing this time around. I tell you what, it makes me nauseated what happened to that innocent young man. And I think he's got a nice lawsuit that he can bring. David Bruno, would you speak to that, please? Oh, we don't have your audio, David. That's okay. Let's see if we can get you repaired. I'll come back to you.
Oh, I'm here.
Okay.
My apologies.
Yeah, back up, my friend.
I
Go ahead.
see it a little differently, Julie, respectfully. I see it through the lens of the defendant. You know, I am a former homicide prosecutor. I sit in the defense chair right now. And the third-party culprit angle is really a constitutional right. And when it's curtailed, it really bothers me. I do understand that there's some factual issues surrounding Colin that would be able to play out in front of the jury. The fact finder could assess the credibility of the particular evidence. Curtailing the Higgins and Albert opening statement too bothers me a little bit, you know, because I think there's a little bit there. Obviously, the injuries on the decedent and how they came to be versus whether or not it was an animal versus whether or not it was the taillight. I mean, that's always in question. And then finally, Julie, also, what she also is not allowing is the arguments about the deficiencies in the law enforcement action. That's curtailing again. They have a retired FBI agent that is there to talk about what a investigation should be, the type of investigative tactics and leads they should be following up. And they're also prohibited from getting into that angle. These are three big blows to the defense. It's going to look very different than the first trial, and it may end differently as well.
David, appreciate your point of view as always. Roberta Glass, let me go to you next, please. Your thoughts on this?
Well, it was quite ridiculous to hear David Yannetti argue in court just because there's no evidence that something happened with any of these three alternative suspects doesn't mean we can't use them. And that's because based on he used his own case. This was the case Commonwealth versus Finney, the case of Marion Alexander's killer, Roland Douglas Finney, who David Yannetti and his sister Tanis got out of prison after a decade after he served more than a decade in prison, and on some very improbable and laughable suspects, and he created precedents with that quite disturbing bamboozle of the courts that he did with getting Roland Finney out. And just like Karen Reed, no one else has been charged or convicted of the murder of Marion Alexander, and just as with no one else has been charged or convicted of the murder of John O'Keefe. It's very similar.
Right, Roberta. And, and let's talk about that because Karen Reed was, blowing the horn as loud as she could about her case when nobody knew who she was or what her trial was. She and her attorney went to the federal government and said, you got to investigate this. There's corruption everywhere. Somebody else did this. My client's being framed, yada, yada, whatever was said. And they found nothing. They found she wasn't being framed. They didn't indict anybody. They essentially, their lack of finding any other evidence that anything else went wrong shows that they got the right person. Jennifer Coffindeffer, in light of that, how successful do you think this third-party culprit defense that they want to put on, and though they might be allowed to do something with the two Bryans, is going to be?
I don't think it's going to be successful. Look, to your point, this is rumor. This is speculation. There's not one iota of fingerprint evidence, of DNA evidence, of video evidence, of any evidence that they had anything to do. They have no motive, nothing to do with his death. So it's preposterous.
I couldn't agree more. Hank Brennan has spoken up and articulated very well how, third-party culprit, and David Bruno, let me go to you on this. It's not without rules. Right. You can't just say, oh, I think I'd like to point the finger, at Julie Grant because I feel like it. No, there has to be all sorts of things substantiated in Massachusetts, motive, intent, opportunity. Knowing that, how do you think that this is going to play out? I mean, truly, David, with Brian Higgins and Brian Albert, these two veterans who served our country, have served in law enforcement for many years, who weren't even near him that night when he was dropped off at the house. There's no evidence John O'Keefe ever set foot in the home. How do you truly think this is going to play out, David? Do you think it's going to be the same thing as last time, like a big nothing burger?
Yeah, we'll see. Hung jury maybe or guilty. I can't see them acquitting her. You got to be careful about what you are trying to prove as a defense because you don't have to prove anything. It's proof beyond a reasonable doubt. It's all on the prosecutor to prove the case. But when you start to go after two individuals like they have, their credibility is going to be at issue too. And we'll just see how this one falls.
Yeah. Roberta, let me go to you. A last word, please, on Karen Reed and all the talking that she's been doing all over the place. How do you think that's going to affect the trial?
Oh, I think she's turned out to be very unlikable. I think she's turned a lot of people off.
Mm-hmm. Yeah, I agree. We'll see what happens with the jury. It's wonderful having you back on the show. Check out Roberta's podcast, The Roberta Glass True Crime Report. I'll be listening, and we'll have you back soon. Agent Coffindeffer, thank you so much for your time. And that little cutie pie in your shot. I see a cute little kitty cat. Oh my gosh. All the animals are always welcome on opening statements. And David, you're coming with us. We thank you for that too. Just ahead, we're going to talk about another big case we've been covering, the Rachel Morin murder case. Her family attorney and friend of the program, Randolph Rice, is joining us live. Plus, the Arizona dad accused in the hot car death involving his daughter. He rejected a plea deal. So we're going to dig deeper into his prior bad act evidence.
Well, let me read this.
All right, folks, buckle up. We're stepping into the courtroom, and things are about to get intense. Keep an eye on how the judge handles this case firm, but fair, or just plain fed up. Let's find out.
This is a court. When you come to court, please dress appropriately, okay? So just so you know, you're not here alone. Your lawyer is here with you on Zoom. Ma'am, you were placed on probation in this court in 2022. We've had many, many issues. Our first motion to adjudicate was filed, it appears, in November of 23. You were placed back on probation. It looks like a new motion has been filed in February for a variety of things. a warrant had been issued, and I guess now you're here with us.
Notice how the judge immediately shuts down any interruptions? This is a crucial part of courtroom control. The defendant might want to plead their case, but this isn't the time that comes later. What do you think? Should judges be this strict, or should they allow more back and forth? Let me know in the comments.
I just don't know how to go forward. Stop. Don't need you to.
Just listen, please.
Just understand that, now it's not time to fight the case. The only thing that we're dealing with now is the motion to revoke, the underlying issues, and what I see is that you're still testing for illegal drugs. I don't know how to go forward, but I don't want to set you up to failure, to set you up to fail as well. So what we do is we have something that's called a TRAS, where I have you evaluated by clinicians to see what is the best way to go forward, because I just don't know.
The judge is clearly trying to find a way forward, but let's be real, getting tested for illegal substances while on probation. That's not exactly making a great case for yourself. Think this approach will work, or is she already on thin ice?
The last thing I want to do is just start pleading people guilty here, left and right, and just end up with, conviction after, no. So the idea is that you leave better than you came. It still hasn't happened. So we need to find out how that's going to happen. So I'd like to please set up our TRAS. Your bond is set now at $10,004. So I have to take you into custody because of the warrant. So I will try to get it done as quick as possible. We could probably have a TRAS done. Do you think maybe tomorrow?
It'll probably still be in processing tomorrow, but by the end of the week.
Okay, we will try to have it done by the end of the week. They will give us guidance on how to move forward, because I just don't know at this point. The only thing I'm going to tell you is please be honest, because if I get it and it says that there's no issues and it's rainbows and gumdrops, and I know it's not true, and we're going to do it right over again. Okay? Okay, so she goes with you. Okay, thanks, Mr. Bernie.
And Your Honor?
Yeah.
If possible, can we try to get the TRAS done by Thursday so she can be in court Friday? Because I'm out.
I will. I'm going to try. So the problem is, though, is that what takes a lot of the time, Brock, is the processing. Because we're taking her in now, it's nearly 11 o'clock. They'll probably still be processing her early into tomorrow. If she's still in processing, they can't get it done.
Oh, whoa, a denied bond request. This is the third case in 2 years. At what point does the system stop giving second chances? Drop your thoughts below. Should repeat offenders get more leniency? Or is this tough love necessary?
Maybe in the afternoon, tomorrow afternoon, it can get it done. I would say probably the latest, today's what, Tuesday? Maybe the latest is Thursday to try to get it done. Then we can try to get the results by Friday.
Okay.
And that's
put it on the docket for Friday?
Yeah. Hopefully.
Can we put it on the docket for this Friday, Your Honor? Like I said, I'm out all next week. I don't want her to.
So because she's in processing, because she'll be processing now, she will auto-populate on tomorrow's docket.
Okay.
And we can put her on for the Friday. So I can't really put her on for Friday yet because she'll auto-populate for tomorrow. But tomorrow, then I will put her on for Friday.
No problem. And can you consider reducing the bond somewhat, Your Honor?
No. This is our third case within the last two years. We've had multiple MAJs. I mean, she's doing what she wants to do, and that's it.
I understand, Your Honor.
Thanks, Brock.
No problem. I will see you Friday.
Okay. I'll reach out to you tomorrow because she'll pop on tomorrow's docket, so I'll reach out to you tomorrow regardless.
Yes, Your Honor. Thank you.
Okay. Good morning. Good morning, Ms. Dixon. Ma'am, you're barred from driving while your license is suspended. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one.
Yes, Your Honor. On February 24th, 2024, at approximately 11:27 a.m., the officer did a license plate check on a vehicle that was shown to be registered to have active Class B warrants out of Montgomery County for driving while license suspended.
Oof. The judge is not playing around here. Do not care what's going on in your life, harsh words, but necessary. This is a classic example of how personal struggles can clash with the law. Do you think strict enforcement is the right approach, or should there be more flexibility?
License invalid and 6 Class C warrants from Humboldt Police Department. The registered owner was shown to be a Black female, and that female was seen driving the vehicle through the lower driver's side window, given the officer reason to believe that the registered owner was currently driving that vehicle at the time. A traffic stop was initiated. The officer made contact with the defendant, who was identified by her Texas driver's license. The officer ran the defendant's information and showed that her license was ineligible and that she did not have any confirmed insurance. The Montgomery County Sheriff's Office and Humble PD confirmed the warrants.
Hey, can you run her license down?
Yes, Your Honor, it is not eligible right now.
And Ms. Dixon, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to drive. I do not care what's going on in your life. If you do not have a Texas driver license and liability insurance in your name, you are not allowed to drive. If I find that you do, I will revoke your bond, put you in jail. Do you understand?
I have one question.
Stop. This is not the time for that. If you need, I can provide you a lawyer today, but this isn't where you just get to start asking questions, really. It's number one. Number two, this is a court. When you come to court, please dress appropriately, okay? So I'll have you go fill out an application with Miranda. I'm going to have you sign everything for you. I'll have you take a seat in the jury box while we get your bond conditions, and then we'll have you speak to the lawyer here in a minute, too. Please. How's Jared? Really? It's good? Fun?
No, it's really not, but I'm blessed to be alive.
Well, that's a good attitude to have. That really is, because it could be a lot worse. You could always be 6 feet under, right?
Right.
Your lawyer is asking me to set you a bond, but I'm really concerned. This case is very old, and you've been out literally, she's been on the lam for 10 years, Dave?
Well, the warrant was on November 9, 2015 for this one, Judge. But the surrender for the judgment roll was on, well, actually, the enrollment date was February 16th, but the surrender notice to file was April 2020. So I don't know what kind of efforts they went, but the actual forfeiture date was in 2015.
Do you know, do they really want, are they going to come?
Like with the other ones, I can only confirm the initial teletype confirming that the warrant is valid and they do still want her.
You've tried to reach out to, I'm sorry, Mr. Kim has tried to reach out to the demanding jurisdiction to see how serious of a case is it? Are they really going to come back? But he's been unable to reach anyone. And I mean, it's only been 30, 45 minutes. So your lawyer's asking me to set you a bond.
Setting a high bond is a strategic move. It's not just about punishment, but also ensuring the defendant actually shows up next time. But $5,000? Is that fair or excessive? If you were the judge, what would you set it at?
Because of the nature of the case, the type of case it is, and because of the age of the case, you're asking for...
Your Honor, the state's asking for $10,000 because it is a possession of controlled substance with intent for oxycodone and the fact that it's been in forfeiture status since 2015. This isn't one where it's a to-be warrant. It's one where she appeared in front of a judge, stated she would return, and then she didn't do that.
You want?
$1,500, Judge. My client has expressed to me that she is a college student. She has expressed to me that she only works for, because she's in school, Uber and DoorDash. She has expressed to me that she has an attorney that is working because she does want this behind her. She can't have this when she graduates in May, if I'm not mistaken. I have explained to her the ramifications if this court was to give her the bond, that she has to that attorney either has to get her a date set there or she has to go turn herself in within the 14 days. She does not have any other criminal history or connection or contacts with police that were dismissed or otherwise, except for this one case from 2015.
The thing is that I have to set your bond sufficiently high so that you understand that we mean business. I'm not going to play this game with you again. If I set you a bond, it's only going to be one time. I won't do it again. You need to understand that there are serious consequences with the actions that you take now. I'm going to set you a bond. I'll set your bond at $5,000. And if and when you make bond, we give you 2 weeks from the date of your release to go turn yourself in to that jurisdiction where you're wanted from. Mr. Kim, where is it?
It's in Mississippi, Harrison County.
So you have to go turn yourself in. If you fail to do that, I will revoke this bond. I'm going to set it at 0. I will issue a nationwide warrant for your arrest. Obviously, I mean, you can't run forever, right? We're going to get you again. And this time I will physically hold you until Louisiana comes and gets you. Do you understand?
I do, Your Honor.
Okay.
So just knowing that he has made the bond for $5,000, is that something that you can, or you or your family is able to post? Because if not,
$5,000 cash?
It's 5,000.
Oh, no, I have a deaf baby. I'm a single parent. My husband died 3.5 years ago. I'm on a fixed income. That's why I do DoorDash, and that's why I do Uber on the side, just to help,
So I said that to say that the waiver, if he sets the bond, then the waiver goes away. They don't come and get you. You don't get to have the bond and wait for them at the same time and see which one happens first. So if you're not going to be able to pay the money, then the option is to leave the waiver that you have in place that you signed on, I think, 2/27, and then let them see if they're going to come get you or not. But you don't lose the time that you've already been in custody.
So I'm confused, when you behind.
What did she waive?
Right off the bat, 227?
So you have 1, 2, 3, 4, 5, 6 days credit. We give them 14 days to come get you. If they don't come get you within the 14 days, we release you. They file a dismissal, I sign it, and then they let you go. If that happens, the warrant will always remain active. And that warrant will always remain active until you physically go back or somehow go back to Louisiana and take care of it.
The judge says we mean business, and it's clear they do. The message here? The justice system isn't here to play games. But what do you think? Does this tough stance work, or does it push people further into trouble? Sound off below.
That said, if you want to make this bond, you have to withdraw that waiver that you have. And then you lose those 6 days. So if you withdraw it and you don't make the bond, you lose all that time. And you basically, it's hold until you re-waive or you make that bond.
I only say this because of the age of the case and the fact that I didn't know she had counsel in Mississippi. It's very, very rare, but I have been seeing it happen here and there, is if local counsel there can get a new setting date. Like I said, it's incredibly rare. I can count on one hand the amount of times it's happened.
What do you mean, get a new setting date?
So even if they don't appear with sufficient evidence, the Marsh Sheriff's Office says she's in our custody and her persons is here, and for a variety of factors, I can't speak to Mississippi because I'm not licensed there and I don't work there, is whatever sufficient factors they have to set a new date for her to self-surrender versus outside of the fugitive, they'll recall the warrant. So like I said, it's incredibly, incredibly rare, but only because of the age of the warrant and the fact that she has counsel there.
But we don't know that.
Well, but I'm saying if the information for that counsel can be sent to.
I mean, I'm not going to give you a PR bond. This case is 10 years old. You've been I need you to understand that we mean business. I'm not here to play games. And so that's why we have to set it sufficiently high so that you realize that you have to have skin in the game so that we know that you're going to go back. I'll let you guys talk about it. I don't want you to make a decision here in front of everybody. So you guys talk about it. You know, I'm not stuck on the 5,000. I go back down a little bit, but it's not going to be much, but
I'll stand down. Thank you, Judge.
So I'll let you guys go talk.
Okay.
I want you to say something here that you might invariably regret because it's in front of everyone, Okay. Please.
Thank you, Judge. Thank you,
I'll
Judge.
go down some, but a reasonable amount.
Wow. 5,000 is a lot of money.
Big day in the Karen Reed retrial as jury selection began today, and it was a bit of a slow start. Just 2 jurors have been seated after one day. Many more were questioned, and dozens are set to return to the Dedham Courthouse tomorrow. We did see 2 new things at court today: a new lawyer by Reed's side, and the impact of the buffer zone on Reed's supporters, as WBZ's Christina Rex shows us.
It does. I feel like it's just Groundhog Day. Karen Reed is back for her second murder trial as 2 jurors were seated Tuesday out of 62 potential jurors questioned. Outside the court, quieter than usual.
They should have just left us where we were. We were fine.
That's because Reed's supporters are being kept hundreds of extra feet from the courthouse for this second trial, outside a designated buffer zone.
Free Karen Reed! I'm very unhappy with being pushed back. I feel like our First Amendment rights have been trampled upon.
The move is to shield jurors from hearing about the case, which is a tall task.
We know that on the subject of this case, there are people advocating for one outcome or another with intensity.
On Tuesday, of the 91 jurors screened, 78 had heard of or discussed the case already. 40 already had an opinion, and 16 said they felt biased for either side.
The likelihood of finding a large swath of people in Norfolk County that have not heard of the Karen Reed case is just unrealistic. So really they have to go to the next inquiry, which is, despite having heard of it, can you still sit on this jury?
Helping the defense with jury selection.
Good morning, Your Honor. Victoria George on behalf of Ms. Reed.
Good morning, Ms. George. Good morning, Ms. Reed.
An alternate juror from Reed's first trial joined her defense team as a lawyer. Victoria George didn't question jurors, but reviewed jury questionnaires and worked closely with Karen Reed.
Amazing. She knows what it feels like to be in the jury pool and how our evidence landed, and she's an attorney, so I just feel so fortunate.
Just to save some time, about 30 prospective jurors were sent home today. They'll be brought back in first thing in the morning for questioning while the other new jurors fill out their questionnaires. In Dedham, Christina Rex, WBZ News.
Interesting. Get ready to go. I'll talk to you guys later. Thank you for joining us. Bye.